Hey, I'm firearms attorney Gilbert Ambler, and we're back today to talk about the aftermath of the Rahimi decision because people have started to ask me after the United States Supreme Court decided Rahimi, which addressed the firearms prohibition under 18 U.S.C. 922 G8, which is for people subject to a domestic violence restraining or protective order. People are wanting to know, after that decision, which upheld that restriction as constitutional, is there any way to challenge these protective orders if you are subject to one? We're going to talk about the constitutional avenues that are left to bring that are challenges to these protective orders that I think are still important and I think are still relevant. But before we dive into that, if you have not yet hit that subscribe button, what are we waiting for? Hit that subscribe button, like, comment with your thoughts, share with your friends, tell me what videos you want to hear in the comments, what you want to learn about. That way you and your friends can keep getting this important Second Amendment related information. Now, as most of you know, Zachary Rahimi, the subject, the named party in the Rahimi case that just came down this month, Zachary Rahimi was not a good dude, very violent. Like 5 or so incidents of shooting off a firearm for no good reason, because the people at Taco Bell didn't make his order right or something to that effect. Not a good guy. And so when the justices looked at this case, 8 justices all lined up on one side saying there's a historical tradition in this country of disarming dangerous people dating back to the time of founding. They still applied that text, history, and tradition test. And they said, looking back to the time of founding, the founders disarmed dangerous people through things like surety laws, and therefore that is close enough to the justices in order to justify the restrictions on banning firearms for dangerous people after a court order today. And I do want to point out, because I know a lot of you watching are going to say, well, we don't think that they really faithfully applied the Bruin test. This is what Justice Thomas said. Justice Thomas said, look, because this was a danger that existed at the time of founding, it should have been a historical twin. And there was no historical twin there. It was a different procedure. The other 8 justices all lined up and said, yes, but at the time of founding, it was understood by the founders that dangerous people could be disarmed. And this is simply a method of disarming dangerous people. So like it or not, I don't get to be a United States Supreme Court justice. Presumably, if you're watching this video, I'd be thrilled if you're a Supreme Court justice. I doubt you are. And therefore, you don't get to decide. We don't get to decide. That's what the Supreme Court does. They said that 922 G8 is close enough to those historical surety laws. That being said, what we want to focus on today is, are there any constitutional challenges left? And before we dive into a constitutional challenge, just a very quick piece of very overarching broad advice. If you find yourself subject to something like a protective order, you might be mad. A lot of times the allegations are made up. If you get served with it, follow the steps. If your state requires you to turn in your concealed handgun permit, turn it in. Be calm, be respectful to the officers, be respectful to the parties in court. The more angry you get, especially if it's made up, you're going to be angry. The more angry you get, the more they're going to use that anger against you. And of course, if your order says no contact with other parties, no third-party contact, obey that. If you start ignoring that and you start texting somebody saying, I can't believe you made this up after you were ordered not to have contact with them, it is absolutely going to be used against you to justify potentially criminal violations and certainly the protective order that's in place. So that's just a quick piece of very basic generic advice. I want to talk about the constitutional provisions for a second, because there are 2 points here that the United States Supreme Court specifically did not address. The first is due process with respect to these protective orders. Due process was not at issue in this case because this order was issued after Zachary Rahimi had a hearing on it. What we are interested in terms of the constitutional possibility to challenge some of these orders, and a lot of you are probably concerned with things like red flag laws and the fact that they get issued ex parte, meaning you might not have that opportunity to participate before the order is issued. The Rahimi case has no bearing on that due process concern. So that is absolutely still ripe for a viable, in my opinion, viable due process constitutional challenge. And in fact, there are some courts in the country that have struck down some red flag laws based on due process. So that's something that people should still be looking for. And frankly, something that may wind up back in front of the Supreme Court at some point. The other thing that I think is really at a very basic level, something that you can differentiate the Rahimi decision from a lot of decisions that might otherwise impact you under 922G8 is the fact that Rahimi specifically involved a finding of dangerousness. The court found that Zachary Rahimi was dangerous, and therefore that would justify the restriction on arms. What about all those people that are subject to an order, for example, going through a divorce that simply says, don't harass the other side? Is that harassment the same thing as a finding of dangerousness? I will tell you right now, under 922G8, it has the exact same effect. If you're subject to a court order that simply says, don't harass the other side, and you had all the due process that 922G8 provides for, then boom, your gun rights are gone for the time being under G8. That being said, that would be a very different challenge. Now, is the Supreme Court likely to hear it anytime soon? I mean, probably not. The government teed this one up with the government knowing full well that Rahimi was a bad dude and the Supreme Court would not like his actions and would want to uphold the constitutionality of the law. A situation where someone was simply subject to a G8 prohibition and all they were was under an order saying don't harass the other side, no finding of dangerousness. It's an interesting case, probably not going to get it before the Supreme Court, but might be something where you could get a trial court judge to understand the difference between what went on. Essentially what I'm telling you is you can differentiate Rahimi on that basis. So if you're out there and you're looking at a protective order and you're worried about your gun rights, and God forbid you get charged for being in possession of a firearm, and this is something that Justice Barrett somewhat questioned a little bit in the Rahimi decision. What about self-defense with a firearm in these situations? Definitely another situation that could change the calculus if you were charged with the G8 violation. That being said, if you are in these situations, my advice always is going to be follow the law. But in terms of if you're already in trouble and you're thinking about defending one of these situations, I would want to look at how a harassment order that says no harassment might differentiate under the reasoning in Rahimi from an order that found dangerousness. So that's another big distinction that still exists. If you enjoyed this content, go ahead, hit that like button, subscribe. Until next time.